When you're dismissed from your job, one of the first questions is whether you can challenge it. Future changes to unfair dismissal law, which are being brought in by the Employment Rights Act 2025, are set to significantly reshape who can claim and what they can recover. So what's changing, and what does it mean for you? The first thing to understand is that unfair dismissal protection is becoming much more accessible. Under current law, most employees need 2 years of continuous service before they can bring a claim. But from 1st January 2027, that qualifying period is being reduced to just 6 months. This means employees will gain protection much earlier in their employment, and employers will need to be more careful from an earlier stage. Another major change concerns compensation. At the moment, unfair dismissal awards are capped, usually at the lower of a year's salary or the statutory limit, which is currently £118,223,000. Under the new rules, that cap is being removed. Compensation will instead potentially be able to reflect the employee's full financial loss, bringing unfair dismissal awards more in line with discrimination and whistleblowing claims. This could significantly increase the value of claims in some cases. This change also takes effect from 1st January 2027. So what about time limits? This is an area where the law is also changing, and possibly sooner. The deadline to bring most employment tribunal claims, including unfair dismissal, will double from 3 months to 6 months. The date of this change is to be confirmed, but it could be as early as October 2026. This gives employees more time to take advice and consider their options before committing to a claim. There are also targeted changes around dismissals linked to industrial action. Since 18th February 2026, dismissal for taking part in protected industrial action is now treated as automatically unfair, and the previous 12-week limit on bringing such claims has been removed. What does this mean for employees hired in 2026? The January 2027 start date has an important practical consequence for people already in employment. Employees hired on or before 1st July 2026 will gain immediate protection on 1st January 2027, because by that date they will have reached the new 6-month threshold. Anyone already employed with 6 or more months of service on 1st January 2027 will automatically acquire these rights on that day. There is no need to wait or take any additional steps. This means a significant number of people currently in work will find themselves protected far sooner than they might expect. Taken together, these reforms shift the balance considerably. More employees will be able to bring claims. They'll have longer to do so, and the financial risks for employers will increase. As a result, getting advice early, whether you're an employer managing a dismissal or an employee considering a claim, is more important than ever. At Duncan Lewis Solicitors, we advise both employers and employees on unfair dismissal, from early resolution through to tribunal representation. Contact us today to discuss your situation.